Yes, Mr. Bennett.
My ladies, my lords, first of all, thank you for allowing the SN to intervene. I have the unusual advantage of having had the last word with my written submissions because they were only filed on Monday. That does mean that you've had the disadvantage of only having had 2 days to consider them. And so what I propose to do, as well as speaking into the microphone, is to take the court through the key steps of our analysis by reference to the printed case. So please do keep it to hand if you don't have it already. I'll start, if I may, with issue B, for the reasons outlined in the preface to our printed case. That's logically anterior, the meaning of Papashvili. And taking the substantive test first, can I take you back to paragraph 8 of our printed case, page 3, which Mr. Malik took you to earlier. This is the target of our submissions on the substantive test, namely the submission of the Respondent Secretary of State that the apprehended significant reduction in life expectancy must both be a consequence of an apprehended serious, rapid, irreversible deterioration in the claimant's illness and lead to death in a short period of time. The Strasbourg court said neither. Lord Justice Sales only included the second of those two features in his judgment, as the court saw before lunchtime. So actually, in this respect, the respondent goes slightly further than the Court of Appeal did in relation to the first of those two glosses. The basis on which the respondent seeks to put this gloss on paragraph 183 of Papashvili is said to be previous case law, specifically D and N, plus realism, which we take to mean policy implications. We make 8 points in response in our printed case at paragraphs 10 to 17. Before I take you on a quick trot through them, I propose to illustrate these points by taking you first to N and then to Papashvili and seek to compare the two cases and explore how the court's thinking has developed from the one to the other. And in doing so, hopefully I'll make most of the points set out in the written case. So please could you take up N? That is MS 1154 is the first page, volume 2, tab 18. And within it, please could you go to 1169. We'll also go on to 1170. And there are 5 central features of the court's reasoning in N that I'd like to draw your attention to. The first feature is paragraph 42, 4 lines to the bottom. The cases in which an Article 3 claim could succeed are characterised as very exceptional. The second feature is to understand why. What was the court's rationale for that? And you see that at the top of MS 1170, Law Report, page 901, the latter part of paragraph 45, the sentence beginning, while it is necessary. While it's necessary, given the fundamental importance of Article 3, for the court to retain a degree of flexibility to prevent expulsion in very exceptional cases, so you see the very exceptional term reiterated there, Article 3 doesn't place an obligation on the contracting state to alleviate such disparities through the provision of free and unlimited healthcare to all aliens without a right to stay within its jurisdiction. And I suggest that's important because when one's dealing with the term exceptional, that begs the question, well, exception from what? What's the norm from which this is the exception? And the norm is that, free and unlimited healthcare to all aliens. And I will go on to submit that our reading of Papashvili does not do violence to that principle. Exceptionality is preserved. So that's the second feature. The third feature, back at paragraph 42, the deathbed paradigm exemplified by D is one such case. The fourth feature at the top of 43, the court doesn't rule out, but equally doesn't rule in other kinds of exceptional cases. And the fifth feature is second sentence of 42, third sentence, a significant reduction in life expectancy is not sufficient. That's ruled out as being something which could bring somebody within Article 3 in this context.
Sorry, where's that?
That is the sentence between the fact that, my lord. So it's the second sentence of the second paragraph of 42. It begins 4 lines down.
Thank you, I've got it.
So I ask you to bear those features in mind when we then look at Papashvili and see what's changed and what's developed. So with that in mind, please, could you go to Papashvili? In the MS, it's 1182. Next tab, tab 19, for those with the hard copy. And can I just start going back to the applicant's submissions? Because, like Mr. Malik said, they put some context into the court's findings, and there's just one feature I'd like to elaborate on beyond that which Mr. Malik drew your attention to. So could you firstly go to paragraph 149, which is MS 1214. And you see there that the applicant asked the court to go beyond its findings in N and sought more extensive protection, highlighting that the case law of the Belgian courts now provided better protection than Article 3. See paragraphs 101 and following above. And I just want to put that submission in context, because I was going to suggest that the court agreed and made good the deficit between the two. So please could you go back to page, firstly, 1199 in the MS, 884 in the law report, and you see at paragraph 95, there's a law, section 9, which has 2 limbs of protection. Picking up in the second line, those who are suffering from an illness entailing a real risk to their life or physical well-being, limb 1, or a real risk of inhuman or degrading treatment if no appropriate treatment exists in their country of origin. So 2 limbs. The first limb is broadly speaking, D, and the second limb is beyond D. And that was then the subject of litigation in the Belgian courts, described at MS 1201 and 1202. You only need read 107, because that's the culmination of that litigation. And you see there, picking up at the second sentence of 107, 2 scenarios are contemplated where this law provides protection. One is D, and then the second concerns aliens who risk being subject to inhuman and degrading treatment if no appropriate treatment for their illness or condition exists in the receiving country. In this case, although it doesn't pose an imminent threat to life, the illness or condition in question must nevertheless attain a certain degree of seriousness. And it was the absence of that limb in the then prevailing case law of the European Court that led the applicant at 149 to say there was a mismatch between the Belgian law and Article 3, and the court ought to step up and fill that gap. And my submission is that's exactly what it did. And so these submissions provide context for understanding what the court did. I now would like to turn to the structure of the critical part of the judgment, which begins at MS 1219. And although it's all under the same title, General Principles, actually I suggest that there are subsections within this that do different things. So the first subsection, 172 through to 175, is what I would describe as a high-level outline of the general principles concerning Article 3. And you see that because it moves on at 176, second line, the general principles outlined above. So there's a recognition of the court that it's moving on to something else at the beginning of 176. And what 176 through to 180 is a narrative, and no more than that, of how the general principles had previously been applied in cases relating to the expulsion of seriously ill foreign nationals. So 177 is a summary of D, 178 is a summary of N, and 179 and 180 are summaries of the post-N cases. Critically, the court's language here is entirely descriptive. There's no commentary. The court doesn't, at this stage, express any view on whether these judgments were right or wrong. It is at 181, the next section, where the court comes to comment. 181 and 182, where the court turns to comment on what it considers to be the unsatisfactory nature of the status of the case law. And in particular, the application of N, fourth line of 181, deprived aliens who are seriously ill but whose condition is less critical of the benefit of that provision. And therefore 182, a resolution to clarify the case law. The third final section begins at 183, and that is the clarification, that is the new approach. So, pausing there, there is no endorsement of N. There is a decision consciously taken to develop the position from N. Now, I suggest that the paragraph 183 and following moves the case law deliberately and decisively beyond N in the following respects in particular. First, whilst N merely didn't rule out the prospect of cases other than the D deathbed scenario qualifying, paragraph 183 positively says that there are such cases and provides a test or approach for those. I haven't got time to take you to it, but can I give you the reference to Judge Lemons' concurring opinion, MS 1231, paragraph 3, he talks about filling the gap. So there's the gap, and the gap's been filled. That's a perfect characterisation of what's been done. Now, that is consistent with N in the sense that N had said there might be another category, and Papashvili said here it is, but it's clearly a significant development of N. In that respect, clarification is an adequate adjective. Second...
I think that's a noun.
Noun, yes, sorry, it is, you're absolutely right. The word was half out of my mouth when I realised I'd misspoken.
Sorry.
Second point, significant reduction in life expectancy is now expressed to be capable of engaging Article 3 in this context, in the circumstances described in 183. I suggest that the use of the same language as in N, in this respect, is notable. You will see when you come to reread the judgment that in the summary at 178, the significant reduction element of what was paragraph 42 of N is repeated. There's a clear contradistinction. In that respect, I suggest that clarification is a euphemism. This was a departure from N. This is inconsistent, to some degree at least, with N. At paragraphs 174, I'm going to have to give you the reference, 174, 188, 189 and 192 of Papashvili, 174, 188, 189 and 192, the court stresses that the key question is the impact on the individual in their circumstances. The word impact is then repeated in Savran for what that's worth. Now, I suggest two things can be taken from that. Firstly, that's a clue to the answer to my Lord Wilson's question, what's meant by significant reduction in life expectancy. And I'd suggest, my Lord, that it will necessarily depend upon the circumstances of the individual. For example, it would be quite different for an 85-year-old to be told they've got 5 years to live than for an 18-year-old to be told they've got 5 years to live.
Or a 75-year-old.
I deliberately calibrated the age. But you get the point, that clearly it simply to have a numerical cut-off would not provide the individual calibration that the court said is necessary. The second thing I take from the focus on individual impact is it's clear from this that it's not the case post-Papashvili, even on Mr. Malik's and my interpretation, that all aliens are to be provided free and unlimited healthcare. Therefore, our interpretation is consistent with the continued use of the descriptor very exceptional. It is not the case, as if I recall right, as Lord Justice Sales said below, on our case, the exception becomes the norm. Finally, paragraphs 184 to 192 set out the process for applying the paragraph 183 test. I set that out in our printed case. Paragraph 183 recognises the primary responsibility on states to fulfil their obligations through what's described as appropriate procedures at 185. I'll turn briefly to these in a moment, but suffice to say now, this too is a development from N. N was focused on the simply the substantive test, whereas now there are related procedural obligations. So, my ladies and my lord, against that background, I want to very quickly, bearing in mind the time and bearing in mind you've got the document, just trot through how that leaves my 8 submissions in my printed case. So please, could you go to paragraph 10? So, first point, the language is clear. For what it's worth, we've looked at the French version. I'm not going to publicly humiliate myself by reading it out. There is a link in our printed case. We have got hard copies if you'd like to be provided with it later. It's identical. So, clear language. Paragraph 11, that's no accident, carefully worded. It's the pivotable passage in a judgment, the very purpose of which is to provide clarification. So, clearly deliberately worded. Paragraph 12, the third point, the formulation has been repeated both by Savran. Now, there's controversy about whether then Savran, the majority in Savran, followed through its own logic in applying the principle, but there's no dispute between the majority and the minority as to what the principle is. The other case where it's been restated is by the CJU, in a reference from this court, MP. You've got that in the authorities, and I've given you the reference there. Next point, paragraph 13 of the printed case. It appears that the respondent accepts, as Lord Justice Sales did below, that her interpretation, what I call the gloss, is contrary to the natural meaning and syntax and structure of 183. Her analysis hinges on what's called case law and realism. Paragraph 14, case law. D is nothing to the point, because D concerns a different category. 183 is plainly dealing with things other than D, so D is of no relevance to interpreting 183. As for N, as I've hopefully explained, the very purpose of 183 and what followed was to move the jurisprudence along from N, in light of the unsatisfactory nature of where the jurisprudence had got to. In light of that, it would be circular and misconceived to suggest M somehow acted as a tether or constraint on understanding 183 so as to subvert the ordinary language. The paragraph 15, it would be, as we say, wrong to read down the clear language for policy considerations. If policy considerations come into, or implications of our reading of 183 are relevant at all, they bear upon whether the court should follow Papashvili, having regard to this court's jurisprudence on Section 2(1)A of the Human Rights Act. That's where policy implications come in, if at all. Then paragraph 16, Lord Justice Sales said the literal interpretation makes no sense. In response to that, we say, there is, as my Lady Hale has said, there is a health threshold. The illness has to be serious. There is the treatment threshold. There has to be a gap in treatment which would result in the impact threshold being one of the two triggers. So this is not some kind of free-for-all, and as I said already, exceptionality is preserved. I'll take the remainder of section B as read, if I may, except in relation to procedure obligations, just 2 points in light of this morning's argument. My Lord Kitchen asked, is the right trigger for the first stage, as I outline at paragraph 21, a prima facie case, i.e. effectively a case to answer. Yes, I accept that, but I highlight at risk of stating the obvious, it's prima facie case of a risk, not the actuality. See paragraph 186 of Papashvili. And note the language used at paragraph 197, final sentence, not without some credibility. So it didn't take much in the court's eyes to put the matter in play and require stage 2 to be gone through. Secondly, my lady, I think it was Lady Arden, asked, did N, the House of Lords in N, comment on the prospects of treatment being actually accessible by the individual in question? Yes, that's set out in our printed case on page 8, paragraph 20, subparagraph 3. And we draw a contrast between the approach taken by their lordships in N, quite rightly, in light of where the case stood, and the approach that would require to be taken now. Effectively, doubt is construed no longer against the applicant, at least at the stage 1 process. That's all I wish to say on procedural obligations. May I turn then, in my remaining time, to issue A, which is dealt with in section 3 of the printed case.
I wasn't actually quite at the point that I meant about prospect.
I'm sorry.
The question of the prospect of somebody actually getting the medication was not regarded as critical in N.
No, in N, the way we put it, and forgive me if I misunderstood, was the fact that it couldn't be said they have no prospect was fatal to the case. Mm-hmm. Whereas now, that wouldn't be fatal to the case because it would be, provided that there was a sufficient concern to engage stage 2, right, then it would be for the...
The question is a prospect of what? If it's a prospect of actually getting them, that wasn't critical in N.
Yeah. Well, I suggest now, really, the prism through which it looked is a prospect of the impact. That's what the court says, for example, in Papashvili, I think it's 192, the one of the passage I gave. That's the focus should be in the court. It's very clear that the question is not specifically the difference in treatment. The question is there a real risk of the relevant impact happening? And if there is a risk of the relevant impact, then the onus shifts on to the respondent.
But there is a detectable shift.
Yes,
in terms of prospect.
Yes, there is. And I asked to compare the passages in those passages in with the ones I've drawn your attention to in Papashvili. So, should Papashvili be followed? I've handed up, hopefully you got it, the case of Hallam. Sorry that wasn't in the authorities provided earlier. Can I take the court to paragraph 89 of my Lord Wilson's judgment, page 472 of the law report? This bears upon the passage that I quote at page 11 of my printed case, the guidelines set out by Lord Mance in the Chester case as to the force of Grand Chamber judgments and the circumstances which would need to be present if this court was not to follow a Grand Chamber judgment. My Lord Wilson, agreeing with Lord Mance, endorsed an earlier comment that these were attempts at guidelines rather than a rigid principle. I fully accept that, of course. I suggest that the approach this court should take in applying the relevant principles in this case is to take the general guidelines as a starting point, and I invite you to conclude the features the general guidelines identify as justifying a departure from a Grand Chamber judgment are not present in this case. That's step 1. And then step 2, I invite the court to ask, is there some exceptional feature that justifies a departure from the general guidelines? And I suggest that there is no such exceptional feature here. In Hallam there was. You thought that the Strasbourg jurisprudence was incoherent. See paragraph 90 on page 472, and see paragraph 73F of Lord Mance's judgment earlier. So there was something fundamentally unsatisfactory about the reasoning of Strasbourg, wasn't the result, the reasoning of the Grand Chamber's judgment, which led you to not to follow it in that case. That's not the case here. I suggest that the respondent may not like what the Grand Chamber said, but she can't tenably say that its reasoning was incoherent or there's something other exceptional feature to justify this court not having regard to it. Paragraph 29 of the printed case, to develop the point made there, I suggest that further force should be given to the Papashvili judgment because it was a considered response by the European Court to criticisms of its earlier jurisprudence. In some sense, it was itself the product of constructive judicial dialogue, albeit principally within the court, against the backdrop of the earlier judgment in N. It's not a throwaway aside or some inexplicable random outrider. And this links somebody to the next point, set out at paragraph 30, 32, my mistake, 32. It's highly unlikely, I suggest, that the Grand Chamber would change its mind if it had the opportunity to do so. As I've sought to explain, and Mr. Malik explained, the debate between the majority and the minority in Savran is not about whether paragraph 183 of Papashvili means what it says or should be refined. It's taking that paragraph as a starting point. Did the majority in Savran misapply it? Because they forgot to ask the relevant question at the crunch part of the judgment. And if they did misapply it, did they impermissibly take the jurisprudence a further step beyond where it should be? So the debate takes the paragraph 183 as unrefined, as the undisputed starting point. So I'd suggest, with respect, that dialogue with the European Court as to whether paragraph 183 should be retreated from would not be a constructive dialogue. I have tried to find out whether Savron's been referred to the Grand. Maybe Mr. Giovanetti can assist us. To the best of the Air Centre's knowledge, it hasn't yet been. The deadline for reference to be made is the 1st of January. By way of a flavour of timescale, Papashvili, the simple chamber decision was July 2014. The Grand Chamber hearing was September 2015, so about 14 months, give or take, 15 months afterwards, and the judgment was December 2016. So about, give or take, 2.5 years from first instance, simple chamber to Grand Chamber judgment.
But might it be said to be unsatisfactory they're dealing with an academic question in Papashvili? Because the applicant had passed away before they got...
Well, they did grapple with that explicitly in the passage Mr. Malik dealt with. So the court recognised that it still had jurisdiction, and as there was a compelling case to revisit the jurisprudence, and the court seized the case to enable it to do that, I suggest it was appropriate. What I would say finally is this: if the court, if your lordship's relation to my lordship decided that some further constructive dialogue with Strasbourg in this general field would be sensible, I'd suggest that the focus of that dialogue would best be on seeking guidance on what Papashvili means, rather than asking the court to retreat from it. In other words, rather than suggesting that it should somehow put a further gloss of the kind that Lord Justice Sales, with respect to him, or the respondent seeks to do, rather than suggesting to it that it didn't really mean what it said, you should suggest that it provides further clarification on what the meaning of what it did actually say.
I've been thinking about what Lady Arden has said about the sad death of the applicant.
Yes.
And yes, it is explained. Nevertheless, the court in Papashvili had the benefit of hindsight. It had the benefit of knowing that with all the wonderful treatment that was available in Belgium, he nevertheless died.
Yes.
And that might have coloured
can I,
the inquiry, which in almost all other cases, of course, is without that benefit.
If it had made a definitive ruling on the substantive test, then I would accept that. But actually what the court did, and we deal with this, if I remember rightly, at paragraph 17, subparagraphs 1 and 2, pages 6 and 7 of the printed case. In fact, we deal with this as a response to Lord Justice Sales's point that actually he saw it as significant against our interpretation that the court didn't make a ruling on the substantive test, but found for the applicant on the basis that the procedural obligations had not been complied with. Well, I said I'd rely on that in response to my Lord Wilson's point, in that the court focused only on the procedural points, partly because what the impact would be on his prospective removal was academic. So therefore, it was very deliberately a retrospective judgment rather than a prospective judgment, and as a result of that, his death didn't infect, I'd suggest, the court's thinking either overtly or covertly. Unless my ladies and my lords have any questions, those are the submissions, I think 1 minute over long. I apologise.
Thank you very much indeed, Mr. Banner. Thank you. Ms. Giovanetti.
Ladies and Lords. Could I start by adopting the respondent's written case, which we have in the core volume tab 7, MS page number 58 onwards. I wonder if I could start by looking briefly at the law prior to Paposhvili, so that we can see the extent to which the Grand Chamber decision in that case changed the legal landscape. I'll then look at issues 1 and 2 together, that should the court depart from N and the United Kingdom, N and the Secretary of State, and what is the correct test applying Paposhvili, before dealing, I hope, rather more briefly with issue 3, the application of the test to the facts of this case, including looking at the procedural approach, prima facie case, what has to be shown by whom, at what stage. So, looking at the law as it stood before Paposhvili, there's been a lot of reference to deathbed cases, but it's really important to understand what was meant by that. As we've seen, in the context of healthcare and medical problems under Article 3, there was only one case that had succeeded, and that was the case of D and the United Kingdom. And rather than turning up the decision itself, there's a helpful short summary in N, in the Authorities Volume 2, tab 18, MS 1165, paragraph 33. It's a long paragraph. I wonder if I could ask the court just to read it. So as I know the members of the court who were in N will very well recall, what was so important about D and what was meant by a death case was that the applicant in D was a dying man. He was going to die whether he was removed or not. The issue was, should he be allowed to remain in the United Kingdom and die with dignity and care? He'd formed bonds with his carers, he'd received counselling about dying, and all the evidence suggested that he would really be dying in the most appalling circumstances if he was sent back to St Kitts. He had no family support, there was no proper provision of palliative care, and the case was about, D was about where and in what circumstances should he end his days in the face of inevitable death, whether here in the United Kingdom or back in St Kitts. The significance of that emerges from the judgments in this court, and indeed in Strasbourg in the N case, because there was no question of the host state, in that case the United Kingdom, taking on the responsibility of providing long-term and expensive healthcare from limited resources. And just to make that point good, I'll just take you to a few references from N domestically. That's in volume 1 at tab 10. It starts at MS 842. Could I ask you first to turn to MS 850? It's a speech of Lord Nichols at paragraph 15. And he was making the point that, again, that D was the only case that had succeeded, and that after that, and indeed before that, there had been many, many healthcare cases which had either been rejected on full examination or more often had been found inadmissible. Lord Nichols said, is there then some other rationale, having said that obviously, and I think this point that my Lady Hale made as well, the humanitarian pull of such cases is very considerable. So is there then some other rationale underlying the decisions in the many immigration cases where the Strasbourg court has distinguished D's case? I believe there is. The essential distinction is not to be found in humanitarian differences. Rather, it lies in recognising that Article 3 doesn't require contracting states to undertake the obligation of providing aliens indefinitely with medical treatment lacking in their home countries. In D and in later cases, the Strasbourg Court has constantly reiterated that in principle, aliens subject to expulsion cannot claim any entitlement to remain in the territory of a contracting state in order to continue to benefit from medical, social and other forms of assistance provided by the expelling state. Article 3 imposes no such medical care obligation on contracting states. That is so even where, in the absence of medical treatment, the life of the would-be immigrant will be significantly shortened. But in D, unlike the later cases, there was no question of imposing any such obligation on the United Kingdom. D was dying and beyond the reach of medical treatment then available. If we turn on to MS 856, in the speech of Lord Hope, it's the end of paragraph 36, just the final sentence. It was the fact that he was already terminally ill while still present in the territory of the expelling state that made D's case exceptional. And then finally, at MS 868, paragraph 69, the speech of my Lady Baroness Hale. The test in this sort of case is whether the applicant's illness has reached such a critical stage, i.e. he is dying, that it would be inhuman treatment to deprive him of the care which he's currently receiving and send him home to an early death, unless there is care available there to enable him to meet that fate with dignity. And while we're at this page, of course, we have Baroness Hale's recognition that there may be other exceptional cases with other extreme facts. Where the humanitarian considerations are equally compelling, the law must be sufficiently flexible to accommodate them, which is the approach, again, echoed by the Strasbourg Court when the case reached that stage. And I won't take you to it now, but just for your note, the exact same approach was adopted in N and the United Kingdom, we'll be going to it in a moment. It's volume 2, tab 18. Starts at MS 1154, paragraphs 42 to 44. So that's what was meant by deathbed cases, that people who only had a very, very limited time left, whether or not they were allowed to remain. Now, insofar as that was treated as the only exception to the general rule that foreign nationals cannot remain in a host state in order to benefit from medical care, it's common ground and accepted that that's no longer the case in the light of Poposhvili, no longer the approach adopted by Strasbourg. In fact, the approach domestically was never quite that absolute. Not only did my Lady Baroness Hell recognise that there might be other exceptional cases, you don't have them in the bundle, but you may be interested to know that cases involving children had always been treated as exceptional. So, for example, there's a case called CA and the Secretary of State, a Court of Appeal decision, Lord Justice Laws, where the applicant was a woman who had one very young child and was also pregnant. And Lord Justice Laws, giving the judgment with which the other members of the court agreed, said that it was obvious simply as a matter of humanity that for a mother to witness the collapse of her newborn child's health and perhaps its death may be a kind of suffering far greater than might arise by the mother's confronting the same fate herself. And that case did succeed under Article 3. And I'm aware of a number of other similar cases where the Secretary of State simply did not pursue removal when either the applicant was a child who was ill or the parent who had sole care of a young child who would be left without anyone to look after him or her in the returning state. So it's not right to say that deathbed cases were the only exception, but as a matter of general approach in terms of adults, in the absence of something else, they were certainly primarily the recognised exception to the general rule.
Have we got CA in the bundle?
You haven't.
Well, could you just give us the reference?
Yes, I will. It's 2004 EWCA Civ 1165.
Thank you.
And if you'd like us to send copies through, I'm sure we could do that.
We
I'm
can-
so sorry.
we
I
can
remember
manage it for
vaguely
ourselves.
and
Thank
found it at the weekend when
Thank
I was
you.
preparing. So, against that background, insofar as deathbed cases have been seen as the only exception, I think everybody's agreed that further guidance, clarification from this court is required in the light of Poposhvili. But just to be clear, we are not asking this court to row back from Poposhvili. In terms of constructive dialogue, we're not suggesting that the Strasbourg court may change its mind. What we're saying is, firstly, that the Court of Appeal's reading of Poposhvili was correct, and that if there is doubt as to what precisely the Grand Chamber meant in paragraph 183, that is where there is room for constructive dialogue to clarify what the court meant by the formulation there for the other exceptional cases. So, turning back to the Court of Appeal's reading of the key paragraph of Paposhvili, which is paragraph 183. We've been through it already. I hope you'll bear with me if we go back to it for a moment. It's at core volume, tab 9, MS 123. Paragraph 38 of the Court of Appeal's judgment sets out their interpretation of what the Grand Chamber said at paragraph 183. You've been asked to read a sentence here and a sentence there. I could read it all out, or could I ask the court just to read the whole of paragraph 38, because the reasoning needs to be read as a whole in my respectful submission. Now, the appellant and the intervener say that the Court of Appeal fell into error essentially by not understanding or appreciating the significance of the word to in the middle of the sentence from paragraph 183. Because it's clear that the Court of Appeal read it as applying where substantial grounds have been shown for believing that the applicant, although not at imminent risk of dying, would face a real risk on account of the absence of appropriate treatment in the receiving country or lack of access to such treatment, of being exposed to either a serious, rapid and irreversible decline in his or her state of health resulting in intense suffering, or a serious, rapid and irreversible decline in his or her state of health resulting in a significant reduction in life expectancy. So the second, that's how it would read naturally if the word to wasn't in between.
Or if instead of saying to, it said in.
Yes, that would be another way of achieving the same result, absolutely. Now, in my respectful submission, that would be a very powerful argument if one was interpreting a domestic statute or a contract. But the reasoning of the Strasbourg Court calls for a rather different approach. I recall when this court was considering the Article 8 deportation cases, my Lady Baroness Hale said at one point in argument that one often gleans more from looking at the outcome of a series of Strasbourg cases than by trying to minutely analyse the language used. And I'd respectfully adopt that, and it's absolutely right. But of course, here we don't have the benefit of that because we don't have a series of cases following Paposhvili showing which sorts of cases have succeeded in Strasbourg and which haven't.
Fair enough, Ms. Giovanetti, but before we leave 38, the third and fourth lines correctly quote the Paposhvili Grand Chamber,
My Lord, yes.
though not at imminent risk of dying, would face ... Okay, so they're broadening it out from imminent risk of dying. Move down, if you will, Ms. Giovanetti, 13 lines, and see what the Court of Appeal there say. Defined by the imminence, i.e. likely rapid experience, of intense suffering or death. So, on the death side of it, they're talking about imminence. Even though they're 13 lines above, they've correctly quoted the Grand Chamber as saying it goes beyond imminent risk of death. Do you follow me?
I do, and that's why I started off by looking at what had been meant by deathbed cases until that time, because what was necessary until Paposhvili, or the way N had been read, was limiting the exception to those who were at imminent risk of dying, whether they were removed or not. So I think if you read 38 in the round, what the Court of Appeal was saying is the focus isn't anymore on is somebody at imminent risk of dying, whether they remain in the host state or not. The focus is no longer on their situation where they are. We're now looking at what would happen to them if they were removed. And I think, so it's a shift in the focus of the inquiry from the position in the UK or the host state to the position in the removing. And I think that's what, if one picks it up, 1, 2, 3, 4, 5, 6. Six lines from the bottom. In other words, in the Court of Appeal, in other words, the boundary of Article 3 protection has been shifted from being defined by imminence of death in the removing state, which I've been calling the host state, even with the treatment available there, to being defined by the imminence, i.e. likely rapid experience of intense suffering or death in the receiving state. So the place they're being removed to, which may only occur because of the non-availability in that state of the treatment which had previously been available in the removing state. And then overleaf at paragraph 39, they give a number of reasons for that conclusion. We adopt all of them. But could I just try and summarise what I'd say probably the key point is very shortly? One is talking about a degree of suffering that meets the Article 3 threshold. In a case of where it's not a life expectancy case, but a suffering case, that suffering needs to be imminent. It's common ground. A serious, rapid and irreversible decline in his or her state of health resulting in intense suffering. That's the first clause. Nobody's calling that into doubt. It would make no sense to say somebody is excluded from protection if their intense suffering won't happen until some years hence. The suffering has to be a result of a serious and rapid decline. And the second part of the sentence, the significant reduction in life expectancy, should be read in a way, a justum generis, in the same way. There would be no logic to saying the Article 3 harm, if it's suffering, must be rapid, must be imminent, but it's enough, if it's a life expectancy case, for someone's life expectancy to be reduced from, say, 20 years to 10 years. So the harm won't happen for another decade. Could one say that a halving of life expectancy from 20 years to 10 years is insignificant? I doubt whether most of us would say that. But in terms of reality, that's why Lord Justice Sales, as he then was, went on to say we're talking about months, not years. We're looking at imminent harm, not harm that will occur possibly, presuming no advances in medical treatment or change of circumstances, in some years' time. And he went on to explain that at paragraph 40 of the judgment. which we've only looked at very briefly, but could I invite the court to read that? It's at MS page 124 and over to 125.
The last part of paragraph 40 is precisely the point that you've been making to us.
Yes.
Probably results from a similar point you made to the Court of Appeal.
I beg your pardon?
Probably results from a similar point you made to the Court of Appeal.
Do you know, I can't recall if it's a point that came from me or whether it came from the court and I agreed and
Gratefully adopted it, yes.
Yes.
So we read this into the word significant. Is that what it comes to?
Well, I think that was my Lord Wilson's suggestion before the short adjournment, that one can come at that maybe there's not very much between the parties if one reads that into the word significant. So one either reads to as in, or doesn't place a great deal of weight on to, and reads the whole of the sentence as being a complete whole to be read together, or one interprets significant in this way. But what's important, bearing in mind the significance that the Strasbourg Court and this court has always attached to the fact that the convention's to be interpreted in a way that doesn't impose disproportionate burdens on the signatory states, burdens that they would not have signed up for. It's not interpreted so that anybody who has an illness which, given the disparities in healthcare around the world, would result in them having a shorter life expectancy if they returned to their home country, had a right to stay and have long-term NHS treatment in the United Kingdom. That's where the real difficulty would lie. So it could really be said that all that lies between us is, how do you read significant? It was an entirely fair point by my Lord Wilson. There are a number of ways of getting to the same point.
Is it really tenable to get to it by reading to as in?
I'm so sorry?
Is it really tenable to get to it by reading to as in?
My preference would be just to read to out completely.
But why? Because it suits the end result.
Because for all the reasons that the Court of Appeal has given and that we have given in our written case, there would be no coherence or fairness or consistency in the Strasbourg Court approaching those two limbs so very differently. We just don't think that can conceivably be what the Grand Chamber meant. Particularly as, I mean, it's in the Court of Appeal's reasoning, and they put it more eloquently than I will, but particularly as there was no disapproval in any way of the key principles that were cited by the Grand Chamber in N and the United Kingdom, and the principles that informed its approach. One of those being, I know my Lord Wilson slightly taken aback by it, but the fact that inherent in the Convention is the search for a balance between the needs of the individual and the public interest of the community as a whole. And I don't think that it's very presumptuous to be saying what the Grand Chamber meant, but I don't think the Grand Chamber there was in any way suggesting that this was a qualified right in the way that Article 8 is, that you conduct a balancing exercise on the facts of individual cases. Not at all. I think what they were saying is that the whole of the Convention is formulated with that balance in mind, which is very much why you have some rights being qualified. So the right to privacy, for example, and other rights that can be interfered with so long as it's proportionate and in the general public interest. And what the Grand Chamber was saying that it was that Article 3 had to be interpreted in the same way, that the reason there was a high threshold was to try and respect that balance between protecting individual rights but also having regard to the general public interest. But for my purposes, I'm entirely content that you approach it by interpreting significant reduction in life expectancy consistently with the first part of the test.
Plus the fact the person is seriously ill, and so forth.
Yes, absolutely. Absolutely. And of course, it will only arise in cases of serious illness. I mean, really, that's not adding to the test, because somebody is not going to have a significant deterioration in their health leading to severe suffering or a significant reduction in life expectancy because they've got some much more trivial sort of illness. So it's not really adding very much to the entire approach to say it has to be a serious illness. That's necessarily the case, I respectfully suggest.
It's going to be a serious long-term illness, isn't it? It's not going to be something that might clear up of its own accord.
No, I think that must be right.
Obviously, the cases have almost all been about HIV, stroke, AIDS, but cancer would be another, or
Yes.
some cancers would be
Yes.
another example. I suppose serious heart disease.
Well, yes. We have leukemia in
Well, that's a
Poshvili
cancer.
itself. Well, I suppose it is. He had other disorders, as you know, as well. There have been cases about end-stage renal failure and, the sickle cell disease was another one.
Yeah.
But yes, they are serious and long-term illnesses generally.
Well, they're clearly serious because that's what they're talking about in paragraph 183.
Yes.
It's a given.
Yeah, absolutely. We've looked briefly at the applicant's case in Poshvili, which I would agree is quite helpful for understanding the approach the court adopted. And if we turn back to volume 2 of the authorities, Poshvili, as you'll recall, is at tab 19, starting at MS 1182. And I wonder if I could draw your attention to MS 1214, paragraph 148. It's part of the section of the judgment that sets out the applicant's observations before the Grand Chamber, which starts at paragraph 139. But you'll see from the last 3 lines of that the applicant there was putting his case on the basis that he was at serious risk in the event of his return to Georgia of a severe and rapid deterioration in his state of health, leading to his swift and certain death. So his was a reduction in life expectancy case, and he put it on the basis of a rapid deterioration. What the Grand Chamber seems to have done is want to make it plain that it didn't need to be swift and certain death, that the test could encompass severe suffering as well. So they've added severe suffering into the middle of the sentence. And it may be that addition or that insertion is what explains the slightly clunky syntax of the text we end up with at paragraph 183.
It's not clunky, it's inconvenient.
Well, inconvenient to me, it would be said. And I'm not going to repeat my submission that it just doesn't seem coherent or principled.
But if you're right in saying that the focus changes partway through, although not at imminent risk of dying in the state where he presently is,
Yes.
but would be if removed, then there would be other ways of saying it much more plainly than that, wouldn't there?
Oh, yes, there would.
See and contrast this situation here with that situation there. It would have been easy to say it.
Yes. it's not always what the Strasbourg court does. It wouldn't
No.
be the only case where one struggles a bit with the language that's been chosen.
Well, the language makes perfect sense on its own.
It makes perfect syntactical sense, but if you look at the principles underpinning it and look for some rationale for treating people who are going to experience severe suffering differently from people who are going to die, it doesn't make sense. It doesn't make any principled sense. I accept it makes linguistic sense, of course. But why would the Grand Chamber want to treat those differently, those two groups of people? So it may come back, as I say, to the point my Lord Wilson made before lunch, that it may be all about how you interpret significant in terms of the reduction in life expectancy.
And if you interpret significant having reference back to the other limb, which is something which is serious, rapid and irreversible, well, clearly death is, but that colours it.
Yes, it does. And one reaches effectively the same end point. Which is why I say I'm entirely content with a reading of it in that manner, but what's important is that the two limbs are consistent with each other and respect the underlying principles that were stated in N and not departed from in any way by the Grand Chamber in Poposhvili, which addressed N at some length and didn't say the time has come to depart from that principle or move on from it. What it said it was providing was clarification of the other very exceptional circumstances.
You associate yourself with the Court of Appeal in having said that in Poposhvili they clearly regarded N against the UK as having been correctly decided.
Yes, I do.
Where do you collect that from?
The fact that what they said in Poposhvili was that more clarification was required in respect of the practice that had followed on from N, not the principle set out in N itself. So if we pick it up, maybe, at MS page 1219, if we start under the heading The Court's Assessment, N is referred to repeatedly in that section, never with any disagreement. So at 172, CN in the United Kingdom, 174, CN in the United Kingdom, 176, CD in the United Kingdom and N in the United Kingdom. Most significantly at 178, where N is dealt with in some detail, the facts are summarised. The reasons for the court's conclusions are summarised.
Mr. Banner says all this bit is just descriptive.
Well, it is descriptive, yes, that's a fair point, but it's not what one would expect to find if the court was going to say, however, we think there are now good reasons for departing from that. The Convention's a living instrument. It's open to us to depart from our previous case. Or they could have said all of that, but they didn't.
But they don't do that.
Well,
What they do is neatly sidestep or develop from what they've previously decided. And I mean, they say fairly clearly, don't they, that that the case law ought to move on. They say that in 181 and 182.
yes, absolutely, but... Sorry, I didn't mean to interrupt.
No, sorry, I didn't mean to grind to a halt. All I'm getting at is that we can't look at their cases. You say we can't look at them as if they're statutes, agreed.
Yeah.
We can't look at them as if they were precedents along the lines of a common law country, because that's not how they operate.
No, I completely accept that, which is why I sort of was making reference to the fact that the Convention's a living instrument and there's a much more teleological approach, if that's the right term. But I wasn't ignoring 181 and 182, I was getting there a bit possibly too slowly. But the point is that at 181 and 182, what the court criticise exactly, but what it says we need to move on from is the practice since the judgment in N of limiting Article 3 in healthcare cases only to deathbed cases. And we don't dispute that it's moved on from that. And plainly there is a more liberal and generous approach to be adopted now. And I'm sure the court is pleased, because I know that N was a really painful and difficult case for everybody involved. These are not easy cases for the courts or indeed for the advocates. But trying...
Everyone seems to skate over 182, and it relates to a point I made this morning about the interpretation of the convention.
Yes.
The jurisprudential basis for moving on in Papashvili is in 182, namely that the previous decision in N did not render the rights of the person claiming protection of the convention practical and effective. And so now they're saying we must interpret Article 3 in accordance with the proper construction of the convention.
I think I would accept almost all of that, but could I qualify it slightly by saying what I think they're saying in 182 is that the practice since N of regarding the paradigm case of a deathbed case as the only case is an obstacle to rendering the right practical and effective, not theoretical and illusory. Because N didn't say this is the only situation in which Article 3 will assist a seriously ill person.
No, but you've got a new benchmark. It's got to be practical and effective.
I think it's always been the benchmark,
Well,
of course.
not sure, really, with the facts of N and D, that's really sustainable.
Well, it wasn't widespread, certainly.
Mm-hmm.
But one has to, I suppose, one has to also read 182 in the context of 183, because the court goes on from referring to the practical and effective, not theoretical and illusory principle, by saying that it considers the other very exceptional cases within the meaning of the judgment in N United Kingdom should be understood to refer to, etc. So it provides that practical and effective remedy in the context of the other very exceptional cases which N already had provided for. I think that's the best answer I can give.
And we've got the fair balance point as well.
Yes. Yes. And there are a number of principles, and there may be a tension between them in some circumstances, and it's trying to find the right place to balance that tension, I suppose, in an area which is, as I say, very uncomfortable for all those concerned, the court and indeed the advocates and the parties, of course, most of all. I think unless the court had any more questions about issues 1 and 2, those were the only respects in which I wanted to develop our case beyond the written case.
There's only one thing that was occurring to me as a result of Mr. Banner having drawn our attention to the citation of Papashvili by the Court of Justice of the European Union in the case that we referred to them, which one can find in the supplementary authorities, page 145, is MP Sri Lanka, paragraph 40.
It'll take me a moment to find that because I only have the MS numbers for this, I'm afraid.
Oh, 1561. It's a kind of really pedantic point.
Makes me nervous already.
Not meant to at all. I just found it instructive because the Court of Justice did not repeat exactly what Papashvili had said. And the way in which they put it actually does not make linguistic sense. Where substantial grounds have been shown for believing that, although not at imminent risk of dying, he would face a real risk on account of the absence of appropriate treatment in the receiving country or the lack of access to such treatment, of suffering a serious, rapid, and irreversible decline in his state of health, resulting in intense suffering, or 2, a significant reduction in life expectancy. Well, the 2 makes no sense at all, because they have changed being exposed
Yes.
into suffering,
Yes. Yes.
which I find interesting.
Yes.
So you could read that particular formulation
Yeah.
in whichever way you want it,
Yes.
because that 2 makes no sense at all.
No. And it's really because the court is trying, I think, in both this case and in Paposhvili, to come up with a formulation that covers a range of different cases. They could have done it by a list, but they haven't set it out in that way.
I just thought I'd toss you that.
Thank you very much. I'm not sure what to make of it. But,
Neither am I, but I found it interesting. Anyway, it looks as if we have exhausted that particular aspect of the matter, and now you want to look at the
Issue 3,
facts of this case.
and I'm not going to say very much about that. I think we've set it out as clearly and concisely as we can in our written case. I think there is agreement that initially the onus must be on an applicant to show a prima facie case. A prima facie case of what? Maybe a slightly more difficult question. And in my respectful submission, it's good to go back, as always in Article 3 expulsion cases, to Sowering as providing the starting point. I'm not going to take you to it, but you have it in Authorities Volume 2. It's paragraph 90, the always quoted paragraph at MS 1357. And what must be shown are substantial grounds for believing that there's a real risk of the harm feared. I think all the parties are in agreement that the approach of the upper tribunal in its very recent decision is broadly the right way to approach these things. They talked of a shifting burden of proof. We'd endorse that. I think it's worth making the point that all of these cases are very fact-specific. So in some cases, the question will be whether the drugs, the treatment required, is available at all in the country of return. In other cases, the issue will be accessibility, whether it's a matter of cost or distance. In other cases, it may be a question of family support that can arise in different ways. So in D, for example, when we are looking at the circumstances in which Mr. D would die and spend his final days if returned to St. Kitts, it was significant there that he didn't have a support structure. He didn't have family or anybody who would look after him. So that was why the family network was important there. In Savran, family support was important, considered to be important, because there was a question about whether Mr. Savran would actually be able to maintain his own medication himself. i.e., would he take his drugs without somebody to support him and prompt him and get him to take the medication he needed? But they're not a tick list. that the Secretary of State or the first-tier tribunal needs to go through in every case, particularly when an applicant's represented, as this applicant was. One looks to see the reasons why he or she says, my health will suffer if I am returned to Zimbabwe or St. Kitts or Georgia. Is this a case that's all about the availability of medication? Is this a case that's all about the unavailability of family support so the medication is actually taken? Is it a case that's about the cost or accessibility of treatment?
Unless we're going to depart from Papashvili and the procedural aspects of that decision, then those procedural aspects will guide this inquiry. There's never been an inquiry under the auspices of those procedural aspects. So you're driven to pick out of a wholly different inquiry, the Article 8 inquiry, and the factual findings relevant thereto, bits and pieces that you sort of say are answers to this completely different inquiry, which may now be mandated.
Well, that's certainly one way of looking at it, but if I could try and put it the other way, the appellant has always been relying on his health. He relied on it under the umbrella of Article 8, presumably because of the obstacles placed in his way by N. But it's been the case for a long time, well before Papashvili, that a healthcare case that didn't succeed under Article 3 could form an important part of the Article 8 consideration if there were other aspects that made it an Article 8 case. So, somebody who was basing their resistance to being deported on separation from, for example, a wife or parents, in the case of a very young applicant, could say, and you need to be taking into account, in looking at the impact on me of separating me from my family, the fact that I am a sick man. And if you look at GS India, I'm going to ask Mr. Dunlop to find the paragraph numbers, that was restated as being the correct approach. That Article 8 isn't sort of Article 3 light, I think the way somebody put it. If healthcare, if medical issues are the only issue, it's not that if you don't meet the Article 3 threshold, you might be able to meet the Article 8 threshold. But in a case where there is a freestanding Article 8 issue, as there was in this one, about separation from family, the medical issues are to be taken into account and weighed in the balance. So it was fairly and squarely an issue before the first-tier tribunal, and indeed the upper tribunal. And that's why, it's in that context, that the applicant adduced the medical evidence and advanced the case he wanted to about the impact of deportation on his health. So the rubric may have been different, but the substance of the issue was the same. What impact would deportation have on his health? And it was put fairly and squarely on the basis that the medication he was receiving in the United Kingdom was not available in Zimbabwe. It was not put on the basis of, I will be returning to a very remote rural area where I can't access medication. It wasn't being put on the basis of, my Eviplera is available in Zimbabwe, but only at a cost, which means it's available to the few and not to ordinary people like me. Now, as I say, if an applicant or an appellant is unrepresented, it may be that the tribunal has to do more in a sort of inquisitorial manner to tease out what the substance of the case is and to help the individual to put forward his case. This was a represented appellant, and it was never put on those bases. And it wasn't put on those bases, i.e. accessibility, affordability, remoteness, etc. It wasn't put on that basis in the first-tier tribunal, nor in the upper tribunal, nor in the Court of Appeal. There's another case that was heard roughly at the same time as this one, which was remitted to the tribunal for more findings about the position on medication, again, the case that Mr. Dunlop and I were involved in, because the appellant was saying, well, there's more evidence that requires investigation. It's not been done in this case. It's been put absolutely foursquare on the basis that I take Eviplera is not available in Zimbabwe. So I think I would resile from the suggestion that the first-tier tribunal in some way had procedural obligations, even had it been an Article 3 case, not an Article 8 case, that they failed to comply with, or that Poposhvili requires a decision-maker always to raise these issues, even if they're not what the individual is arguing or relying upon. So they must be considered if they are live issues on the facts of the case, I would say. That's the procedural obligation. So the applicant has to raise the initial prima facie case of it's not affordable, it's not accessible, and then absolutely the authorities need to investigate that if a prima facie case is shown. So that's what I'd say about the procedural obligation. I'm sorry, I feel as if my voice got rather loud. I didn't mean to be bellowing. I've got rather a cold at the moment. I'm not hearing myself very well. So if my voice goes up and down, I do
We are
apologise.
hearing you perfectly.
Good.
Yes, and as I always say to counsel, it is actually the first duty of counsel to make themselves heard.
Yes, literally, I suppose, as well as metaphorically. So against that background, or in that context, could I turn to a point raised by my Lord Kitchen, which was, well, he's on Eviplera, and we know that Eviplera isn't available. How can either party really put forward medical evidence? Certainly the Secretary of State can't, because the first question is, why couldn't the appellant tolerate the medication he was originally prescribed? And his doctors have been very silent about that. Was Eviplera one of a number of alternatives that they could have prescribed for him as an alternative to that first medication? Or was this a case where, in their judgment, once the first medication wasn't tolerated, if Eviplera was it, that was his real alternative? And in all of these cases, realistically, the position has to be that it's for the appellant, claimant as he is in the first instance before the Secretary of State, to put forward the medical evidence as to his own needs, his own medical diagnosis, prognosis, and the treatment he requires. Where the state or the authorities can assist in clarifying the matter is by trying to establish what the real position is on the ground in the home state. So the Secretary of State will often be in a better position to make inquiries of, for example, there are various networks that provide information for information sharing between EU member states as to the availability of treatment or medication in various states. So those sorts of inquiries, which may be harder for an individual to make, are much easier often for the Secretary of State to make. But as to the person's own medical condition and the treatment he requires, that's really something that he needs to advance. So we say that whether one looks at the test in paragraph 183 of Poposhvili disjunctively or not, and whether the two is critical or is not critical, the appellant in this case simply hasn't met either of those tests. To put his evidence at the highest, I think, it's that he would suffer the language was a premature death, or he would die sooner than he would otherwise. He faced the risk of a premature. But there's nothing there about significant reduction in life expectancy, or particularly any indication of the sort of reduction in life expectancy. You'll remember that in Poposhvili itself, the medical evidence before the court was that a person who was taking Mr. Poposhvili's medication would have a life expectancy of 3 months if it was discontinued. And the court, someone made a reference to less than 6 months. The 3 months reference is at MS, page number 1191. It's paragraph 46 of the judgment. Beginning 14th of July 2015, a new medical report. Penultimate paragraph, it's clear from the medical literature that if ibrutinib is discontinued in such a situation, the average life expectancy is 3 months. Again, in N, there was evidence before the court that if the appellant didn't get her medication, I think it was 1 to 2 years was her life expectancy. But there was nothing like that before the first tier tribunal. And if the appellant can produce such medical evidence, it is of course open to him to make a fresh claim. I think that's agreed all round. But such a claim ought properly to be made initially to the Secretary of State, who, if the evidence is sufficient, in the light of the test, as this court says it is, it may well be that it never needs to go back to the tribunal because Secretary of State will apply the test to the evidence, and it may well be that the appellant would succeed on the fresh claim without more.
So you would say that that's a better course to take than us propelling the parties into further litigation before the first tier tribunal?
Yes, absolutely. And really the appeal should only be allowed and the matter remitted if there was a material error of law in the Court of Appeal's decision, we would respectfully say. And we say, even if you disagree with the precise way the Court of Appeal put the test, you'd need to find that they put it in a way where this appellant, on the evidence that he'd put forward, could realistically have had a prospect of success in order for any error to be material. And we say that on no version of the test that's put forward could this appellant on this evidence have succeeded.
And what weight can we give to the information we've been given about fresh evidence?
Which information is that, my lady?
It was said this morning in the course of submissions that there was materially new. We haven't been given any details, but there was a reference to new evidence that would substantially...
I wonder if it was new because time had gone by.
I don't know if it was a reference to a footnote that we had put in to a recent report saying that HIV/AIDS medication is now all free in Zimbabwe. If it was that, we don't make any great point about it, but just if the situation had got worse, we'd felt obliged to draw it to the court's attention, and it hasn't, quite the contrary. I don't know, maybe Mr. Malik would, just because I don't understand what the reference is to. New evidence?
The point simply was that if the matter is to be remitted to a further fact-finding hearing, the appellant will reduce further evidence as to his present state of health.
Thank you. And I think that's answered my last point, that ought to be considered first by the Secretary of State, who might well make a decision in his favour, well, who will, if it's justified, be bound to make a decision in his favour without the matter troubling the tribunal, the Court of Appeal. Could I just check with Mr. Dunlop that and those instructing me that there's no important point which I've omitted to make? Thank you. Mr. Dunlop's given me very kindly the references to the Article 8 approach to medical care cases. I said it was summarised in GS India. It's volume 1 of the authority, tab 5, MS 703 to 708. Paragraphs 85, 86 and 108. I seem to recall that the underlying judgment is a judgment of Lord Justice Moses, but it was adopted and endorsed by the court in GS India. Unless there were any other matters that I could assist the court with, those are my submissions.
Thank you very much indeed, Giovanetti. Mr. Dunlop? You've put your tuppence in.
My lady, if I may very briefly just intervene, I'm having handed up to you the hard copy of the French language version of Papashvili. The reason why I'm now providing it rather than asking if you'd like it is the French language version of the ECJ judgment is identical, which may answer your
Lady Black has
thought.
already drawn my attention to that.
There you go.
One of the advantages of having machines.
Indeed.
Yes, thank you.
Cheers.
Mr. Monk.
Just a few short points in reply. First, my learned friend made a submission as to the possibility of what she says would be a constructive dialogue. And she suggests that this court can ask the Strasbourg court to clarify what it meant at paragraph 183. It is, in my respectful submission, relevant to recall that in that paragraph, the Strasbourg court, as it said at paragraph 182, was already providing a clarification of the principles. So what my learned friend is asking this court to do is, in effect, is to ask the Strasbourg court to clarify the clarification that had already been provided. The clarification that has been provided, in my respectful submission, is clear. There is no room for any doubt. My learned friend sought to defend the reasoning of the Court of Appeal at paragraph 38 of its judgment in this case. This is at page MS 123. And if I've understood the position correctly, what my learned friend is saying is that this court should either omit the word to or read that word as in, or construe the word significant in a way that links it with the first limb. In my respectful submission, there is simply no justification for reading out to or to read it as in. The Secretary of State makes that submission, in my submission, simply because she is not happy with what the Strasbourg court has said. And I do respectfully invite the court to recall what Lord Hope said in the case of N at paragraph 25, namely that we should take the Strasbourg jurisprudence as we find it, as opposed to how we would like it to be. Learned friend then makes a submission that the word significant has the same effect as serious, rapid, and irreversible, as it appears in the first limb. I accepted in the course of my submissions that word significant has a significance. It requires some assessment, but in my submission, it would be wrong in principle to read that word so to mean precisely what is said in the first limb. If this is what the court had intended, the court would have said so. Seriousness of a person's state of health. In one sense, that involves a different consideration from the assessment of whether reduction in the life expectancy is significant. When it comes to significance of reduction matters that are relevant, as Mr. Benner QC submitted, included, for instance, a person's age. And I do, in relation to that part of my learned friend's submission, ask the court respectfully to look at paragraph 107 of Paposh Valley. My learned friend, Mr. Benner, took the court to that paragraph. It is at MS page 1202, behind tab 19 of Authorities, Volume 2. This is where the court summarized the effect of domestic law, and you'll see that, as Mr. Benner highlighted, there were two scenarios. The first, of course, was about the imminence of death, but the second, freestanding, was the risk that a person would face without there being imminence of death. And that was the gap that, as Mr. Benner submitted, the court sought to close in its analysis. So my submission is that if what my learned friend Ms. Giovannetti submitted is to be accepted, then that may bring back the gap that the court in Paposh Valley sought to close. My learned friend Ms. Giovannetti then submitted that the court in Paposh Valley cited the decision in N, but did not say that that was wrongly decided. That, in my respectful submission, is not significant, as Milady Lady Hale pointed out. It would be extraordinary to see a judgment by the Strasbourg court whereby it would expressly say that the earlier case law was wrong. What the court did makes, in my respectful submission, perfect sense. It referred to the case law as it stood at the time. It then said at paragraphs 181, 182 that case law was not satisfactory and sought to develop it by saying what it said at paragraph 183. What is said at paragraph 182, as Milady Lady Arden said, is of particular relevance. One has to construe Article 3 so that its protection is practical and effective, not theoretical. And that is how I would respectfully invite the court to read paragraph 183. If the court accepts the submission that my learned friend Ms. Giovannetti has made in its entirety, in my respectful submission, that would again render Article 3 as providing protection no more than a theoretical protection. Reference was made to the decision in MP in the course of the submissions. This is at volume 3 of the authorities volume. It's MS 1555. And Lady Hale, of course, was troubled with what is said at paragraph 40, which appears at page 1561. May I respectfully ask the court perhaps to also look at paragraph 41? That may clarify what is said at paragraph 40.
41 where, sorry?
Sorry,
MP.
41 of MP,
Yeah.
MS page 1561.
Thank you.
It's in the supplementary bundle. So.
Yes, thank you.
Doesn't mention life expectancy in 41. Unless I've missed it.
No.
I wasn't necessarily troubled, I was just curious.
My learned friend, Ms. Giovannetti, accepted that what was said by the upper tribunal's presidential panel in AXB is correct. That was about the shifting burden of proof. In my respectful submission, there was simply no regard to that by the first-year tribunal in the present case. My learned friend says that the assessment is fact-specific. I accept that, but my submission is that fact-specific assessment is missing. My learned friend says that the appellant had always relied on his health as part of his claim and had used evidence, but as Lord Wilson pointed out, that was in an entirely different context, where the appellant was seeking to pursue an Article 8 claim in a hope to demonstrate that there are compelling circumstances that would tip the proportionality balance in his favor. The procedural protection that come with Article 3 do not apply to Article 8. The position in relation to burden and standard of proof is not the same. And when the matter was considered by the fact-finding tribunal in 2014, the appellant did not know what to aim for when he had used evidence that was adduced before the first-year tribunal. In my respectful submission, the proper analysis is that the first-year tribunal considered and determined the claim under Article 3, but it applied the wrong test. Not only it applied the wrong test, it also erred in relation to burden and standard of proof, and it did not make the findings on matters that are material to the outcome. If that submission is accepted, then the court should remit the case to the first-year tribunal for reconsideration on the correct legal basis, because the Court of Appeal and the upper tribunal were wrong to uphold the first-year tribunal's decision. The Court of Appeal also, in my respectful submission, applied the wrong test. And even if it had applied the correct test, in my submission, it erred in relation to burden and standard of proof. And it also made its decision without having the benefit of factual findings on material matters. Now, my learned friend says that despite all that, it would be more convenient for the matter to be dealt with by the Secretary of State. Well, if the court prefers that approach, then in my submission, the court should proceed to quash the Secretary of State's decision made in this case, and that would enable the Secretary of State to remake the decision, having regard to all the circumstances. But in my respectful submission, it is not an answer to this appeal that the appellant may simply make a fresh claim which the Secretary of State will consider. I emphasize
Well, I don't at the moment understand why a fresh claim under Article 3 would require the original Article 8 claim to be quashed.
the Secretary of State's decision that triggered the appeal proceedings not only refused the applicant's Article 8 claim, but also refused the Article 3 claim
I see.
by saying that the high threshold is not met. And I took the court to the relevant part of the decision where Article 3 was considered, and I made submissions as to why that approach was defective in the sense that no consideration was given to material matters. If the Secretary of State wants to consider the matter before they are considered by a fact-finding tribunal, and if she is not content with quashing of the first-year tribunal's decision and remittal, then in my respectful submission, the underlying decision should also be quashed. As it is well settled, the first-year tribunal is an extension of the executive decision-making process. At the first-year tribunal, the appellant will be able to give evidence, live evidence, as to the matters that were considered material in Paposh Valley, and the first-year tribunal will decide the case one way or another. That is not to push the parties in further litigation, but in my submission, it will bring finality to the proceedings. But I do emphasize again, with respect, that I'm not saying that the case should be remitted to the first-year tribunal simply because there is now new evidence that the appellant wishes to place before the first-year tribunal. That isn't a proper jurisdictional basis on which the court can interfere with the decisions made below. My case is that the courts below applied the wrong test. Their decisions are wrong. And if their decisions are wrong in law, the usual course of action is to quash those decisions and to remit the matter to the first-year tribunal. This is not a case where this court can say with certainty that there will be no breach of Article 3, unless the court takes the view that the outcome is inevitable. In my submission, the appeal should be allowed with an order that the case be reconsidered either by the upper tribunal or by the first-year tribunal. Perhaps the final point that I will perhaps highlight is in response to what Malone Friend said as to the way in which the case was pursued at the first-year tribunal. Malone Friend said that it was never suggested by the appellant that access to medical treatment was an issue, but in my opening submissions, I did take the court to the relevant parts of the evidence given by the appellant at the hearing. Perhaps just to give the reference again, this is paragraph 28 of the first-year tribunal's decision, MS page 147. The appellant said that he his wife would not go with him. He has no cousins or relatives in Zimbabwe. He has done some courses here, but those courses would not help him because Zimbabwe is a different country, he hasn't been there since the age of 13. In my submission, that was enough for there to be a proper consideration of whether the appellant would be able to access the medical treatment. And it's also relevant to see how the submissions are framed. They are at pages 57 to 87 at MS 151, MS 153. So after the evidence is given, the Secretary of State sums up the case first and explains why a person's appeal should be dismissed and why that person's removal would be compatible with Article 3 or Article 8. The appellant then responds to that case. And in my opening submissions, I took the court to the only relevant paragraph that one finds in the Secretary of State's submission, that is at MS page 152, paragraph 72. The Secretary of State said no more. The Secretary of State addressed the Article 3 claim and said that, well, the medication is available, and that's all. No submissions were made, it appears, by the Secretary of State as to the accessibility of the medication. That is how the case was put to the first-tier tribunal by the Secretary of State.
The medical certificate, medical report
Yes.
for the first-tier tribunal is one that I believe we find on 193, Mr. Malik. Am I right?
That is correct, but of course you have other reports at
If
89.
we turn over to 194 and read the penultimate paragraph, we've got the HIV clinical nurse specialist saying if he were to be returned to Zimbabwe, doubtful as to whether he'd be able to obtain ARV medication there or the blood tests required, certainly be unable to obtain his current regimen. We know about that. If we were unable to obtain treatment, the disease would progress with a fall in CD4 count, susceptible to opportunistic infections, eventually lead to death. So there was that contribution from the nurse.
Yes. I'm grateful for that.
Yes, very well.
My learned friend, in that context, made a point that the doctors have been quite silent about the effects of a different drug. I mean, of course, no one raised that point as to how significant the side effects would be until the point was made by the Court of Appeal for the first time in its judgment. If the point wasn't raised by anyone, I wonder how the appellant can be expected to deal with it. Given that Lord Wilson has referred to the letter at page 193, may I also ask Lord and my ladies to look at the letter at page 191. And if one looks at MS page 192, the last two paragraphs are relevant, where there is a reference to the appellant developing infections, cancers, and premature death. Of course, there is no assessment of what is meant by premature death, how significant the reduction would be in the life expectancy, for understandable reason, namely that no one knew that that was relevant when the decision was taken. That again is a matter that should be considered by the first-tier tribunal. But I'm showing these letters to the court, not to invite the court to embark on a fact-finding assessment or to substitute a decision one way or another, but simply showing that there was enough before the first-tier tribunal, and there is enough that would give rise to a claim that is capable of success. This is not a case where the outcome is inevitable, namely that there would be no breach, and therefore it would be appropriate for the appeal to be allowed and the matter to be remitted to either the first-tier tribunal or the upper tribunal. These are my submissions in reply.
Thank you very much indeed, Mr. Malik. We're most grateful to everybody for their submissions and the clarity and economy with which they have been presented. You have managed to save the court a whole half day of hearing time. And it's not that we don't like listening to you, it's just that we have other things that we can usefully do with our time, which will include thinking out what the answer to this case is. And we will let you know in due course in the usual way. The court will now adjourn. Thank you.